Good morning. We are glad that you could join us for the webinar this morning. My name is Chris Banaszak, and I am the chair of our Labor and Employment Group. About 2 months ago, we did a webinar just as things were starting to close down, and now here we are about 2 months later, doing one as things are beginning to reopen. And I know a lot of businesses out there have really run the gamut in terms of how this has impacted them. There are essential businesses that have been essentially operating as usual. There are some businesses that have been much busier than usual, and then there are other businesses that have been deemed non-essential that have been essentially shut down and unable to operate. So, I know this has had a very different impact depending on the nature of the business that you're in. And there's been a lot of information out there on reopening. I've seen, 40, 50, 100-page manuals on what to do in terms of reopening. I've seen a lot of articles that have suggestions or indications of things to do on reopening, some of which have indicated that employers can exclude certain categories of employees from the workplace if they're at higher risk, which I know we'll talk about later as something that you should not be doing. I think the intention of this webinar was to give you some practical advice on what to do in terms of reopening, how to do it, things to be wary of from an employment standpoint. And just to introduce you briefly to each of the speakers here today, I will start out by doing some introductory remarks, and then there will be a brief presentation by myself and Laura Ferrari. Laura is another attorney in our Labor and Employment Group who's done a lot of work related to the COVID pandemic and the impacts that it's had on employers. Just recently worked on a client alert that we sent out dealing with issues related to reopening. She will be talking about some of the background reopening issues, as well as talking about different potential retaliation and harassment issues that could come up. We will also have a discussion by Brittany Lopez-Naled. Brittany does a lot of work with employer safety issues, in particular in the OSHA area. She will be talking about instituting changes to try to increase workplace safety in light of COVID, and what to do if an employee tests positive for COVID-19. And then Rob Scholl, who was my predecessor as head of the Labor and Employment Group, has too many awards and accolades to list here, but has extensive experience in a wide variety of employment issues. We'll be talking about how the National Labor Relations Act can impact reopening. And I know oftentimes companies that are non-union don't think a lot about the National Labor Relations Act, but even for non-union employers, there are provisions of it that could come into play here that you'll want to consider. Rob will also be talking about wage and hour issues that might arise during reopening. And then Shannon Toole, who is also an attorney in the Labor and Employment Group, who has done an extensive amount of work and research related to the CARES Act and the new leave laws that have come out as a result of the pandemic. We'll be talking about implementing medical testing in the workplace, and also about addressing accommodation requests and leave requests. And a lot of these things, again, if you were an essential employer, you may have been dealing with some of these issues already. For those who weren't and are reopening, some of these things may be issues that you have not yet had to deal with. And then the last portion of our presentation will be by Rebecca Green, She's a shareholder in our employee benefits group. Has a wide range of experience on advising employers on a variety of different employee benefits issues. And she will be talking about some employee benefits considerations that have come up or things that have changed as a result of the pandemic and the new laws and regulations that have come about as a result of it. So, one of the first issues that we'll just again run through as sort of background is the timing of reopening. Again, if you're in a business that's been open throughout, this may not be as much of an issue for you, but there may be some restrictions that were in place that are not now. I think, as most of you probably know, last week the Wisconsin Supreme Court struck down as invalid the safer at home order that was in place in Wisconsin that was set to expire on May 26th. Now, that decision does not mean that all businesses within the state can immediately resume normal operations. Instead, unless there are some new state limitations which have not been implemented yet, local government will likely be the primary source of any restrictions going forward. And for companies that operate in more than one location, it may present some challenges in terms of what you can and can't do, depending on what county or what city you may be operating in. I know for companies that do work around the country, there are some of those same issues outside of Wisconsin. In other states, for example, in California, there's a statewide rule, but then there are also a number of different county and city ordinances that are in effect that may have different restrictions than what the state has in place, and that's here in Wisconsin certainly the case now. After the Supreme Court's decision came out, there were a number of counties that re-implemented orders that were essentially the same as the state order. A number of those have now rescinded them, and at least at last count, this is sort of an unofficial tally, but Dane County, Door County, Eau Claire County, Florence County, Greene County, and Rock County still, at least as of this weekend, had some variation of the state order or different orders that were in place. Milwaukee County also has some restrictions that apply both in the city and in suburban areas. The city of Racine and the city of Mequon also have restrictions in place. So, as part of this reopening process, depending on where you operate, it will be important to look at what's out there, currently, depending on your location, to see what restrictions are in place, because a lot of these orders have been issued by municipalities have different restrictions. Some are more limited, some are identical to the state restrictions, but there is a lot of variation. One of the other considerations as part of this, once you've decided that you are going to reopen, is planning for it and having a return to work team. You need to, I think it's important, especially depending on the size of the business that you have, that you assemble a team that is going to be primarily responsible for preparing the transition plan and coordinating the logistics of the employee's return. It's important to have someone or a group that is the primary source of the communication and information for the plan. I think one important aspect of that is to have regular and consistent communication. You also have to be flexible and able to adapt to changing circumstances. Over the past couple of months, a lot of the guidance and rules that have come out have changed as we've gained more knowledge of the virus and how it operates and what safety procedures work well and what don't. And I expect that to continue to change going forward over the next several months. So it's going to be important to stay on top of that, because something that may be appropriate now may change. Things that are recommended right now are likely to change. So it's important that whatever team you have in place who is going to deal with this be situated so that they can stay on top of all the changes that are happening. And with that, I will turn it over to Laura Ferrari.
Thank you, Chris. So as Chris mentioned, the Supreme Court's decision and local orders are probably going to be the most impactful in figuring out when your businesses are going to be able to open. It's important, though, to have a plan and accompanying procedures in place before you have employees return to the workplace. The decision and the order sort of loosening those statewide restrictions should not be a green light to just swing open the doors and have everyone come back and rush back in business as usual. Instead, companies should be using this time to look back over these past few weeks and months now to determine what has worked, what hasn't worked, and what needs to change in the immediate future in order to determine how to best prioritize personnel and operations management to best kickstart business. For example, I think a lot of us have been hearing anecdotal evidence that for those job functions that can be performed remotely, many employers have found that it has been less painful and a less inefficient process than many had originally feared. So even if your business is able to return to normal or to resume opening, if you have employees that have been successfully able to work remotely, consider whether that's an arrangement that you can continue in the near term to help ease that transition back to the workplace and limit those movements into the office of employees. Now, for those employees who are going to be returning sooner rather than later, they should not expect that it's going to be business as usual, so to speak. You should prepare them for the fact that things are going to look and function differently and communicate these new processes to them once the return is possible. Now, many companies are going to be focused, and rightfully so, how to mitigate the negative impacts of the pandemic on business operations and how to most effectively and efficiently resume those operations. But don't forget to factor in your employees' return into your business continuity plan. Because we've not experienced a pandemic like this in modern history, most of these types of plans don't take into consideration the lingering effects that this particular disaster is going to have. This isn't, for example, a flood whose waters have subsided and we're now in recovery mode. We'll be dealing with the coronavirus, unfortunately, for the foreseeable future. And companies are going to have to continue to address employee safety, both from a practical standpoint, but also from a more personnel management standpoint, and trying to reassure employees that you're doing what is necessary to keep them safe and to keep your business humming along. Again, like Chris mentioned, for that reason, it's really important to assemble a return to work team that can address those issues. Now, as far as the actual return of your employees are concerned, as I mentioned earlier, employers shouldn't plan to have everything return as though the pandemic never happened. It's your duty as an employer to ensure that your employees are safe at work. And again, from a morale standpoint, employees should feel as safe as possible under the circumstances when they return to the workplace. Although it's likely that many of your employees are going to feel some level of anxiety in returning to work, there are things you can do to help put their mind at ease and help that transition. And one of the ways you can do this is by implementing some of the practices that we've all become familiar with over the last couple of weeks, including social distancing. And one of the easiest and most effective ways to ensure that employees are practicing social distancing in the workplace is by having fewer employees present at any given time. So for example, having a less densely populated office is going to allow the employer to station employees every other cubicle or every other workstation, or if we're talking about a manufacturing operation, to have them spread out a bit more on the line than they would otherwise. So having those sort of built-in social distancing practices in place. The question though then becomes, how do you determine who to bring back and when to bring them back? Again, although the statewide order has been removed, you're going to have to look towards your municipality and your county to determine what is appropriate for your business to reopen and when. But beyond that, much of the consideration, I think, is going to be determined by how much of your workforce can continue to remotely work and whether there are certain positions or departments or functions for which operation out of the workplace is going to be critical. And certainly it's okay to prioritize those. But whether you have a plan that involves a gradual return to the office on a rolling basis, or whether you plan to have employees return sort of all at once, but in a staggered schedule, you should make sure that these decisions are not based on an employee's protected characteristic or disproportionately affect employees of a certain protected group. And I think disability and age are going to be the ones that are most salient as far as this pandemic is concerned. It's going to be the case where well-intentioned employees who, out of nothing but concern for their own employees' well-being, might want to require older employees or an employee with a disability, perhaps asthma or some other respiratory function disorder, to stay at home longer than they would other employees, or to prepare a plan that allows for a gradual reintroduction into the workplace, but has those employees sort of last in line. Having those sorts of plans might be problematic from a discrimination standpoint. The decisions on who to rehire and who to recall should be treated like other types of employment decisions, like hiring and promotions. And as you know, adverse employment decisions like this can't be made based only on these employees' protected characteristics. Now, it will be entirely possible that there are other factors that need to be taken into consideration with respect to employees' age or disability, for which, for example, an accommodation might be necessary. But again, those blanket prohibitions or plans that are based only on a protected characteristic might be problematic from a discrimination standpoint. We'll be talking a little bit later about accommodations under the ADA, but in terms of preparing your current employees for returning to work, you should keep in mind any current accommodations that might have been provided to an employee before quarantine. You might have to reconnect with those employees to determine whether that pre-existing arrangement must be modified, whether because the employee has a new or unique need due to the coronavirus, or perhaps the accommodation that you had set up in the first place is no longer workable, whether it's too costly or perhaps from a safety standpoint, especially if you have an accommodation that allows those people to work in close accommodations with other individuals. For example, a disabled employee that has someone working closely with them to assist in their disability, that might be something that needs to be modified given the fact that we want to be maintaining those social distancings while we're in the workplace.
All right, next up is Brittany.
Hi, and I'm going to be talking about once you've made the decision to reopen, what are some things you should be thinking out about for how to safely reopen. And, one of the things is going to be planning and making sure you're getting on top of all of this before you bring everybody back. And there's a lot of guidance out there, but you want to make sure that you think of several things. First of all is none of these are going to be one size fits all, and you may need to have various plans for your workplace based on different workspaces or different job functions. And as Chris mentioned, if you're an employer with multiple facilities, you may be covered by multiple local or state orders that you're going to need to also monitor. A great place to start is OSHA and the CDC have both put out various guidance information, and a lot of it is industry specific for best practices for reopening, or for those of you that were essential businesses and are still open, for kind of reincorporating additional employees into the workplace. So I've included the links for those two websites. Those continue to be updated. OSHA added additional guidance last week for nursing homes and long-term care facilities, and for rideshare. I know that CDC has similar guidance for rideshare. There are some discrepancies between the two, so I would definitely check both of them. CDC has various guidance for airlines and different job functions within the airlines. In addition, if you are in Wisconsin, the Wisconsin Economic Development Corporation also put out guidance documents. There are 15 industry-specific documents, and there is one for general industry. And so I would take a look at those and see what best practices they're recommending. Finally, you want to make sure to check your local, whether it's county or city orders, and see if there are any additional requirements. I know that for some of the local public health orders, they have various restrictions on restaurants and childcare and retail that you'll want to make sure that you keep an eye on also. As Laura mentioned, we want to be social distancing within the workplace. That is going to be one of the most important steps, and it's kind of a multifaceted effort. So once you have kind of assessed how to limit the number of people in the workplace, whether that is not bringing everyone back initially, having people telework, you also want to consider other than employees who's in your workspace. So are there visitors or vendors that come on site, that we can limit those visits or do them virtually. Same with meetings and non-essential travel, reconsidering those policies, whether those should still be limited or restricted. Once you've limited the number of people in the workplace, then you want to determine where are the areas where people are gathering, where you're going to have increased risk of exposure. And so that means, you know, when you have people coming in for the day, do you have time clocks, elevators, locker rooms? So if you do have those places in your facility that kind of become a bottleneck for employees, is there a way to limit that by doing staggered work starts, whether you're starting people, you know, 10 to 15 minutes earlier or later to kind of reduce that traffic jam. Same with limiting capacity of elevators, locker rooms, maybe saying 2 people per elevator, and making sure within the elevators you're indicating where people should be standing so that they're as distant as possible. Obviously, I think with most elevators, even having 2 people in them can be problematic. You know, elevators are just not that large. So also consider if you have break rooms or cafeterias, whether those should be open, and if you choose to keep them open, whether they should be limited to a certain capacity. And if you have a store or somewhere else that has aisles, whether you want to be directing traffic to all move in one direction to reduce the amount of people that are kind of crossing paths with one another. Other reorganization of the workspace can include physically moving desks and workspaces to the extent possible, blocking off with either tape or removing chairs from workspaces that you don't want used, and doing other modifications. If you have a production line, if it's possible to space people out, those are other ways just to maintain that physical separation. However, not every job is going to be conducive to employees being 6 feet away from each other at all times. There are other options that are available to create that physical space. One thing that we've been seeing a lot of is the introduction of plexiglass. If you have been to the grocery store or other vendors, you will see that that is normally between the cashier and the customer to kind of create some space. OSHA recommends use of plexiglass on production lines where you cannot create that space otherwise. And then finally, to the extent you have people that are in common spaces or working near each other, consider whether face masks would be an appropriate addition to your safety plan. You want to make sure that you're keeping your expectations very clear and being transparent, and also providing reminders. These are all going to be new changes for everyone at work. So if you're limiting capacity for conference rooms, make sure there's clear signage, remove extra chairs, have visual cues if you have reduced numbers of people you're allowing in restrooms or cafeterias, have a line and markings where those people can be standing, because otherwise, you know, 6 feet creeps into 5 feet, creeps into 4 feet as we've been in the workplace longer. So if you have the tape on the floor, people just know where to stand and it's a little bit easier. In addition to these kind of physical changes we can make, you're also going to want to conduct a personal protective equipment hazard assessment to determine whether your workplace requires other PPE, as OSHA abbreviates it, such as respirators. Most employers who are not medical, postmortem, or lab workers with potential exposure to suspected or known cases of COVID-19 have no requirements for respirators. They may need gloves, so you'll want to do that assessment to determine whether that's appropriate. If your hazard assessment does not require that your employees wear a respirator, you should still consider whether your local or state orders require employers to provide face masks and or gloves. We're seeing a lot of states that are requiring that in some counties, so definitely keep an eye on that. And if you are required to provide any sort of face mask or gloves, make sure that you are prepared and you have those before you reopen, and also that you're prepared for accommodation requests for that. If someone has a respiratory condition, they may not feel comfortable or be able to safely wear a face mask. You may have allergies that require gloves with alternative materials also. And in terms of the other like high touch surfaces or something you're going to want to look at. So doorknobs, light switches, if you have a break room that is still open, is there a microwave, a fridge, printers, copiers, those high touch areas need to be sanitized frequently. And you also want to see if there's a way to limit the touches on those. If you can leave certain doors propped safely, pursuant, that aren't violating fire code, can you do that? Is there an option for any sort of touchless soap dispensers, paper towel dispensers, doors, anything like that that you could implement? And to the extent some of these are just going to be touched frequently, make sure you have disinfecting wipes and sanitizer already ready when everyone comes back to work so that they can disinfect before and after use of things like that. Consider if there are tools that are being shared and that is unavoidable, that those employees maybe should consider wearing gloves if they can't be sanitizing the tools in between each use. Kind of tied into that, cleaning and disinfecting is making sure that your cleaning and disinfecting processes are consistent with the CDC guidance. And so you can go on their website and they have helpful guidance for employers and businesses on what specific disinfectants are approved. And then once you make those required changes, make sure you're also assessing whether those different chemicals require PPE for the people doing the cleaning, such as gloves or masks, and that you have reviewed the material safety data sheets and you have those available for your employees because they are entitled to request those. I'm not going to get into too much detail about medical testing because Shannon will be talking about that, but you want to consider whether to include any temperature checks, COVID-19 checks as part of your safety plan and document this plan. You're putting the work into doing the planning and the implementation, so make sure you've documented it and you're communicating it with your employees. And that is going to be one of the best ways to reduce people's anxiety about coming back to work. And if you can reduce that anxiety, you reduce your risk that someone feels unsafe and makes a report with OSHA or a similar state plan or another agency. So also make sure you're doing your training. That way the employees understand exactly what they should be doing, how the exposure risk is being reduced. And some of it seems a little bit common sense, like hand washing and respiratory etiquette, but it doesn't hurt to make sure that everyone is starting from the same baseline, understand symptoms and what to look out for, and make sure your leadership is fully trained and is setting a good example. You also want your leadership to be prepared for employees to raise concerns and make sure those concerns are taken seriously. They're brought up to your team and addressed, and you communicate to the employee that you did assess it and let them know what changes you made. As Chris mentioned, it's evolving, so you're going to want to continue to stay on top of the guidance and make changes where unanticipated kind of exposure or risks may arise or as the guidance evolves. As part of your training, you want to encourage sick employees to stay home. If someone is feeling ill at the workplace, you want to make sure your plan provides for immediately segregating that employee and sending them home. And your return to work should also address, what do we do if someone does test positive? And so again, the most important point is to immediately send them home or segregate them from other employees, but then also understand what information you need from them. You need to understand where they have been working in the past 48 hours so that space can be fully cleaned and disinfected. And you also need to know who they were working with. So once you can figure out who they were working with, and that means within the past 48 hours, who did they have close contact with, so within 6 feet for anywhere from 10 to 30 minutes. Once you have that list, you can do your contact tracing and have a supervisor or manager reach out to those individuals and let them know they were potentially exposed. We'd recommend having a script for that because that is confidential medical information. So you want to make sure the employee's name is not being used and identifying information is not being provided that could tip off who it is. Then those individuals who were potentially exposed to the coronavirus should stay home and self-quarantine for 14 days. regardless of whether they're having symptoms. There are some exceptions for that, for people as part of the critical infrastructure or essential workers, but Wisconsin is reading that very narrowly and saying that is only for healthcare workers, and otherwise employees should be staying home. The next question then is, when can those employees come back to work? And the CDC has two different criteria based on whether or not the employees got the COVID-19 test. If they got a COVID-19 test, they have to wait until they have 2 negative test results 24 hours apart and no fever and improved respiratory issues before they can come back to work. If you don't get a test and you've talked to your healthcare provider and they're not recommending that, or say you don't need it, your fever has to be gone for 3 days, improved respiratory conditions, and it has to be 10 days since your symptoms appeared. And again, that guidance continues to evolve, and so make sure that you are staying on top of that to best advise employees when they can return. Final note is just to remember that COVID-19 is not under the exception for kind of the seasonal flu, which OSHA does not require to be reported or recorded. So COVID-19 that is work-related may need to be recorded on your OSHA 300 log, and if it results in inpatient hospitalization or fatality, may need to be reported to OSHA. And they do have guidance on that. They've given a little bit of enforcement discretion for anyone who's not in the healthcare, corrections, or emergency response industries, but you'll want to just make sure that that is in your plan too, that you assess whether or not it needs to be recorded or reported. And now I will turn it over to Laura, who's going to talk about how you deal with some of these employee safety concerns.
So as Brittany mentioned, it's a very real possibility that employees will be apprehensive and voice concerns about their safety in returning to work. It's important to know that employees who are just generally concerned about the coronavirus and what returning to the workplace might mean for them, they are by and large, absent extenuating circumstances, not excused from being absent from work on that basis alone. However, if an employee does refuse to report to a facility due to a dangerous or hazardous working condition, this refusal could be protected under the Occupational Safety and Health Act, which prohibits employers from discharging or discriminating against employees for exercising a right that is protected under that act. The regulations acknowledge that there might be some circumstances where an employee is effectively forced to choose between whether they want to perform their job duty or whether they are going to expose themselves to a serious risk of injury or death arising from a hazardous condition at work. So what happens if the employee chooses the latter, to refuse to work? Well, the good news in this regard is that the threshold for refusal to work, for it to be protected, is fairly high, and the following 4 factors must be present in order for that to be protected. First, the employee has to have asked the employer to eliminate or mitigate the danger, and the employer fails to do so. The employee's refusal to work has to be in good faith, meaning that the employee genuinely believes that there is imminent or impending danger in performing that work. 3, a reasonable person must also agree that this condition poses a danger of death or serious injury. And the last one is that there's not enough time for the hazard to be abated through the typical channels, for example, requesting an OSHA inspection. So again, unless these 4 factors are met, employers aren't allowed to discipline employees for refusing to work. But again, we want to make sure that if employees are raising concerns, we want to take those seriously, because on a less extreme end of the spectrum, employees have the right to raise concerns about their safety in the workplace with employers. We'll probably end up seeing this more in industries or positions that normally require PPE or certain equipment that's in short supply due to the pandemic. But we also have seen this come up in these large-scale facilities where employees typically work in close contact. So the concerns raised by employees might be relatively easy to address, or due to cost or scale, it might be nearly impossible. But regardless of whether the particular concern being brought to your attention is easily mitigated, as best practice as an employer, you should be doing what you can to address employee safety concerns. So take those concerns seriously, and if you can mitigate or address those concerns, by all means do so. But if nothing else, having a conversation with an employee about what you're doing to keep the workplace safe is going to go a long way. Even engaging in a dialogue about what you are doing to make sure your employees are safe is going to help reduce the risk that they're going to feel the need to, like Brittany mentioned, file a complaint with an administrative agency or other governmental body. So having those lines of communication with employees and making sure that they feel comfortable coming to you with concerns. And again, whether those concerns can be addressed reasonably is a different story, but having that open dialogue with them will help ease their fears in returning to the workplace and help them feel more self-assured that you're doing what you need to do to keep them safe. Along with OSHA, the National Labor Relations Act does provide employees, regardless of whether they're in a union, the right to engage in concerted activity for mutual aid or protection. There's similar protections under the Labor Management Relations Act with union employees. So if an employee brings a concern related to workplace safety and management, that might also be protected. But again, Rob's going to be discussing this more in depth a little bit later. Aside from retaliation issues, employers also want to keep an eye out for harassment issues. As many of us have seen on the news, unfortunately, it seems as though instances of violence against Asian American or Pacific Islanders are being reported more frequently. Employers should reiterate to their employees that any type of harassment based on an individual's protected characteristics should not be tolerated, and keep an eye out for any troubling comments or any behaviors and address these as needed. Employers should also be sure that their managers or supervisors are aware that even in light of the dangers posed by COVID-19, they should not be treating their subordinate employees who are older, who have a disability, differently than those employees who do not, again, absent extenuating circumstances that might call for some sort of accommodation. Managers should also be mindful that employees who are older, who have a disability or another protected characteristic, they shouldn't be ostracized by their employee or by their colleagues rather, and they should not be excluded for participating in work activities or functions based solely on the fear that because of their age or because of their underlying medical condition that they would contract COVID-19. Again, we want to make sure that these employees aren't being excluded based solely on those particular characteristics alone. And now, like I mentioned, Rob is going to discuss a little bit more in detail about specific concerns related to the coronavirus and the National Labor Relations Act.
Thank you, Laura, and welcome everybody to my kitchen. I'm first going to discuss how the National Labor Relations Act may impact reopening. The COVID-19 pandemic has led to some increased protest activity in the workplace. Some groups of employees have complained about unsafe or unhealthy workplace conditions or about long hours of employment. And because unions have been a less significant part of the private sector workplace in recent decades, many unorganized employers have little or no experience with federal labor laws and how to legally address such activity and complaints by employees. And therefore, unfortunately, employers may make unnecessary blunders in responding to such complaints, and that can put them in violation of federal labor law. The bedrock statute that governs private sector labor relations, as Laura mentioned, is the National Labor Relations Act. And in particular, under Section 7 of the National Labor Relations Act, all employees have the right to engage in concerted activities for the purpose of collective bargaining or other mutual aid or protection. These Section 7 protections are available to all employees, not just those in the union. Chris made this point earlier, but it's important to underscore that even in a non-union setting, you have to be mindful of employees' Section 7 rights. If employees act in concert, meaning that two or more employees take action together for reasons related to their working conditions, then the employer may not discipline or fire employees for engaging in such activity. And therefore, in the context we're talking about this morning, if employees express workplace concerns related to COVID-19, their protests or their expressing of concerns may be protected under the National Labor Relations Act. Employees have a right, and it's a protected right, to protest their employer's actions or perceived inactions in protecting them from COVID-19 while they're in the workplace. And then I'll give you some examples of protected activities that occur in a COVID-19 context. They include the following: a group of employees bands together to discuss and raise health and safety concerns in the workplace, or a group of employees circulates a petition on the work floor expressing health and safety concerns, or a group of your employees contacts the media to express concern that you're not safely operating your workplace in light of COVID-19. These are all protected activities, and an employer cannot discipline employees simply for taking these actions. Here's another protected activity. A group of employees refuses to report to work because they have a reasonable, good faith fear that working conditions are unsafe because of COVID-19. So as Laura mentioned a minute ago, that concern by employees has to be in good faith and has to be reasonable. But if both those criteria are satisfied, then perhaps their refusal to report to work is justified, and you can't discipline them for that, even though their fear may well in reality be mistaken. Here's another example of protected activity. One employee acting on the authority of other employees or speaking on their behalf raises a concern about a lack of personal protective equipment, or raises a concern that the employer is not following the best practices out there in terms of workplace cleaning practices, some of the things that Brittany spoke with you about this morning. Another example of protected activity, a group of employees request certain work schedule accommodations, such as adjusted start or end times, so that they aren't bunched together coming into or leaving work. Or they may request staggered shifts, or they may request that they be allowed to continue to work remotely rather than have to come into the workplace. Again, these are all examples of activities that may be protected under Section 7 of the National Labor Relations Act. Employers who are attempting to reopen in these very stressful times may understandably be upset when employees decide not to cooperate or do not fully cooperate with the employer's reopening plans and protocols. And employers may well be tempted to discipline or dismiss such employees. However, you have to be wary and aware of the possibility of a retaliation claim under Section 7. If you take action against such employees in violation of their Section 7 rights, that can lead to unfair labor practice charges before the National Labor Relations Board. Employees simply have the right to engage in protected concerted activities, even if you believe as their employer that you've taken all appropriate safety measures and have complied with all governmental safety directives in resuming your business operations. And the issue won't be whether the actual working conditions are safe or unsafe. Instead, the issue is going to be whether you took action against the complaining employees because they exercised their Section 7 rights. So as I think both Brittany and Laura mentioned, you can best avoid such issues by being transparent with your workers about issues of concern, particularly worker safety. Take any concerns expressed by your employees about safety very seriously. Sit down and have a discussion with them about your concerns, and proactively address safety and health concerns. Let them know exactly what you're doing to maintain a safe work environment in accordance with government guidelines and regulations. And again, be very wary about discharging, disciplining, or threatening employees engaging in such protected concerted activities. If you are a unionized employer, then you have some additional labor law issues to think about. When you return your workers and you're a unionized employer, you of course need to adhere to the layoff and recall provisions and the bumping provisions that are contained in your collective bargaining agreement, even if that means you may not be able to call back the exact bargaining unit employees that you'd like to call back first in this context. And moreover, remember that you have a duty to bargain in good faith with your union, and you cannot unilaterally change terms and conditions of employment without first bargaining. This means if you're a unionized employer, this means that as you develop plans to reopen your operations, you may need to bargain over new policies and new safety protocols that you've developed to respond to COVID-19, you may need to bargain over those with your union. Bargaining is generally required. The only exception is if there's a compelling economic exigency that supports your right to immediately and unilaterally act to deal with an immediate safety threat. So if that's the case, of course, go ahead and deal with that immediate safety threat, but otherwise think about your bargaining obligations. Another example for unionized employers, if you want to bring back employees on a work share basis so that you can bring back everyone, but albeit on a reduced schedule basis, you may first need to bargain with your union over that schedule. You'll obviously want to look first to your management rights clause to see what leeway it gives you to unilaterally make operational changes without first bargaining with the union. And finally, many unions are seeking information from employers about what response the employer is making to the COVID-19 pandemic. And these requests often relate to real or perceived safety and health concerns. And I've had clients that have received what seem to be form letters from unions asking for all sorts of information about what steps the employer is taking. These concerns involve a mandatory subject of bargaining, safety, and health, and therefore they do probably fall within information that a union has the right to request from you because it's relevant to the union's representation of bargaining unit members. So unionized employers will most likely have to furnish this requested information to their unions. Okay, I'll now turn to the second topic that I'm addressing today, and that is wage and hour issues that may arise during reopening. There are numerous such issues that may sneak up on an unwary employer and could ultimately lead to collective or class actions being filed against them, which are very costly and take a lot of time and attention. So let's first talk about misclassification of employees. And we're talking about classification in terms of whether an employee is exempt or non-exempt. Because of the pandemic, an employer may well be forced to reduce its workforce and then significantly modify the duties of the employees who are returned to work. And therefore, employers must evaluate whether an exempt employee returning to work remains properly classified as an exempt employee. Is that employee's exempt status still warranted after operations resume if not everyone has returned to work in their customary roles? Do the exempt employees' duties still fit under one of the white-collar exemptions? For example, if a salaried employee no longer supervises the work of 2 or more full-time employees, maybe that exempt employee no longer qualifies under the executive exemption. Or if a returning supervisor who you've treated as exempt is now doing a lot of manual work because all the people he supervises haven't been returned to the workforce, does that supervisor still qualify under the administrative exemption? That supervisor's classification may have changed due to the actual work he's now performing. So you need to look at that supervisor's actual day-to-day duties after returning to work and not simply refer to the duties that were written into his job description. A related wage hour issue is if you've reduced the salary of a returning exempt employee, does his compensation now fall below the minimum required to be considered exempt? Is it still at least $684 a week? If not, then you have to reclassify that employee's status from exempt to non-exempt. And you would have to pay that employee overtime pay for any overtime hours worked. And what happens if you bring back an employee who used to be full-time, but in this COVID-19 context, you're just bringing him back on a part-time basis? If you're doing that and you're also proposing to pay that employee who's now working part-time a part-time salary, you need to communicate that to the employee prior to bringing him back. For example, let's say you're bringing back an exempt employee on a reduced 4-day work week schedule, and therefore you're planning to only pay him 80% of the salary that he enjoyed prior to COVID-19. If you're going to do that, you must communicate that to the employee before she's brought back to work. Otherwise, you're going to jeopardize that employee's exempt status, and you may be required to pay the full 100% salary, irrespective of the number of days that she's actually working. Now let's turn to new or additional tasks that are required of employees as they return to work. As businesses reopen, many employers will consider implementing new safety protocols that are related to COVID-19 and are aimed at ensuring the safety of the workplace. And Brittany talked to you about such measures extensively during her part of this presentation. So for example, if you are now going to administer temperature checks before you allow employees to work, or you're requiring them to fill out questionnaires regarding their COVID-19 symptoms before they start work each day, you may be required to compensate employees, non-exempt employees, for the time that they spend complying with these new workplace screening protocols. Under the Federal Fair Labor Standards Act, employees must be paid for all time spent performing their principal work activity, but also for any time that is an integral and indispensable part of their principal work activity. Some pre and post shift activities are considered integral and indispensable to the work that an employee is hired to perform, and so are considered working time. And if they are considered working time, then you must pay an employee for the time spent in these pre and post shift activities. The issue is not simply whether you require these tasks of your employees, it's whether the task is integral and indispensable to their principal work activities. Accordingly, in our COVID-19 context, you should ask yourself whether the time spent waiting in line to get a screening test and in getting the screening test itself or in filling out a questionnaire is preliminary and not integral and indispensable, or whether, in contrast, it is and therefore has to be compensated. Certainly, the conservative position to take is that screening time and time perhaps spent in donning and doffing protective equipment, PPE that Brittany talked about, is compensable time, is working time, and should be paid for. If you make that conclusion, then you obviously will want to take steps to minimize the time employees spend in line getting screened and in being screened or in donning and doffing PPE. But you could take the position that this is not compensable time. You would argue that this is simply time spent checking in and waiting in line to check in and need not be considered working time and need not be paid for. In addition, or a related issue is donning and doffing, which I've talked about a little bit, but is the time spent on putting on personal protective equipment at the beginning of the workday and taking it off at the end of the workday, is that compensable time? And again, whether an employee must be paid for time spent donning and doffing special uniforms and protective gear depends upon the purpose of the clothing and the PPE and the reason for the mandatory wearing of such gear. So in short, whether these new and additional tasks that are prompted by COVID-19 are compensable is highly fact-specific, and resolution of these issues are going to be driven by complex analyses that involve both a careful review of analogous case law and details of how each employer executes these tasks. Again, there's no clear answer whether these activities must be paid for or not. And obviously employers are going to want to watch carefully for regulations or court decisions that address this compensable time issue for screening and donning and doffing related to COVID-19. In the meantime, obviously, try to streamline your processes to avoid extra wage costs. I'll end then with just a few brief comments about timekeeping. Again, I think we've already heard from Brittany and Laura about taking steps to make sure that employees can safely punch in and out and otherwise safely get to their workstations, and then during the work day, make sure that there's social distancing so that they minimize their exposure to COVID-19. But to comply with your social distancing requirements, you'll want to consider staggering the start of shifts, staggering hours, maybe alternating days of work for different groups of employees. And as you do so, make sure that your timekeeping processes are very accurate, as you would have done before all this started to occur. So that concludes a very rapid review of the National Labor Relations Act and of wage hour issues that arise as you reopen. And I'll turn the program over to Shannon Toole.
Thank you, Rob. Good morning, everybody. So I'm going to be covering medical testing in the workplace, and then I will address accommodation requests and leave requests, specifically the types of accommodations and leave that are arising related to COVID-19 specifically. So beginning with medical testing, I've split this into two categories. So employers should be aware that there are different requirements for medical testing under the Americans with Disabilities Act for applicants and for employees. So for applicants, the ADA prohibits disability-related inquiries and medical exams at the pre-offer stage, so before there has been a conditional offer of employment. So this includes taking an employee's temperature and administering a COVID-19 test. You should not do that to just applicants who you have not offered employment to. You may be able to ask about symptoms of COVID-19. This is an unclear area of the law. However, I would strongly advise not asking about any symptoms until after you've submitted a conditional offer of employment to the applicant, just to avoid any potential liability under the Americans with Disabilities Act. After you offer a job to an applicant, you may then screen the job applicant for symptoms of COVID-19 and take an applicant's temperature, as long as you do so for all employees who are entering your workforce. So basically what we're looking for is consistent administration of medical testing for applicants that have been offered conditional employment. If your applicant has symptoms or has been diagnosed with COVID-19, the EEOC has stated that employers can delay that applicant's start date until they have satisfied the return to work requirements that were highlighted by Laura and by Brittany earlier in this presentation. For employees, the EEOC has clarified that employers may do several things when you're screening employees who are returning to work. You may take an employee's temperature, you can administer COVID-19 tests, and you can ask employees about COVID-19 related symptoms. Now, the EEOC has clarified that employers may require mandatory COVID-19 testing and temperature taking and symptom checks before entering the workplace. And this mandatory bit is important. So the Americans with Disabilities Act requires that any mandatory medical test of an employee be job related and consistent with business necessity. Applying the standard to the current circumstances related to COVID-19, employers may take steps to determine if employees entering their workplace have COVID-19 because an individual with the virus will pose a direct threat to the health of others within the workplace. Therefore, you may choose to administer COVID-19 tests before they enter the workplace. Now, something about COVID-19 tests that employers should be aware of is under the Americans with Disabilities Act, these tests must be accurate and reliable. So what does this mean? Well, the EEOC has pointed employers to the Food and Drug Administration's guidance on testing, which is currently up on your slide. You will see there are 3 websites that employers can go to get guidance on this issue. And the third one is the FDA's FAQ on testing for SARS-CoV-2. So this will tell you what type of tests have been considered accurate and reliable, what type of tests you should and should not be using. It's updated regularly. I checked it on this morning, and there haven't been any additional updates since the creation of this PowerPoint. So I'm going to share with you two things that I want to flag in terms of the types of tests that are allowed. So there was a recent FDA warning that was submitted about one of the rapid COVID-19 testing implementations that you can allegedly take and get results within 20 seconds. So employers should look out for whether or not they have that type of test and whether or not that test is still considered accurate and reliable by the FDA. I know there were some issues with some false positives and false negatives within that test. And also antibody tests. So at present, the FDA has stated that antibody tests cannot be used for diagnosis or infection, because the tests measure antibodies that are part of the body's immune response to exposure and not the virus itself. So, you know, this is kind of a apple and orange situation. So really what we're looking for is whether or not the employee is infected with the virus and not whether or not the employee has developed antibodies to fight off the virus, which is an immune response. Because we don't know if the employee who has antibodies is actually still contagious. We're looking for a viral test to confirm whether or not they presently have COVID-19. So employers should avoid antibody testing and other rapid testing or any other tests that may come on the market until the FDA gives the okay on their accuracy and reliability. So moving now to addressing accommodation and leave requests. First, I'm going to begin with the Americans with Disabilities Act, and then I will move on to the Families First Coronavirus Response Act. These are the two main flashpoints that we've seen in terms of leave and accommodations that are affecting employers and employees as we all return to the office during the pandemic. So the EEOC has clarified, as with any other disability, the burden is on the employee to inform the employer of any underlying condition that may make him or her more vulnerable to COVID-19. So as Brittany and I believe Laura mentioned earlier, there may be some respiratory underlying conditions or other underlying conditions that the Centers for Disease Control has said are potentially make people more vulnerable to a worse case of COVID-19 and make them more vulnerable to potentially succumbing to the disease. So, you know, there are these concerns that people don't want to have people with underlying conditions coming into work. However, as with other disabilities, it is up to the employee to tell you whether or not they have one of these underlying conditions. Now, after receiving a request, then you can engage in the interactive process. You can ask questions, ask for medical documentation as you normally would with any other disability. But avoid going up to people who you know or you think, avoid going up to people who you think may have underlying conditions and asking them this information, because that could run afoul of the Americans with Disabilities Act. So wait until after an employee has told you that they have an underlying condition. So another complicating issue with this is actually the FFCRA. I'm going to touch on a documentation issue briefly and then make one final note about the Americans with Disabilities Act. So as I mentioned, under the ADA, once you are informed of a disability or potential disability from an employee, you can then ask for medical documentation and other information. To take leave under the FFCRA, it is possible that an employee with an underlying condition can take the leave if they have been advised by a healthcare provider to self-quarantine. However, the FFCRA is very limited in what employers can require from employees in terms of medical documentation. So it is possible that in one sitting, an employee could say, hey, I have an underlying condition and my healthcare provider has advised I stay home, so I want to take 2 weeks of emergency paid sick leave under the FFCRA, which I am entitled to. If you're going to ask that employee for underlying documentation related to their disability, be sure that you are documenting the differences between the two. So the Department of Labor has clarified in the FFCRA states that if an employee is advised to self-quarantine by a healthcare provider, you can only ask for limited information, and that is the employee's name, the date the employee requested leave, the reason for the leave, a statement that the employee is unable to work because of the stated reason for leave, and also for the self-quarantine due to a healthcare provider's advice, you can ask that they provide the name of the healthcare provider who gave that advice, but based on other Department of Labor guidance and the text of the law, it is unlikely that you can require an employee to give you any additional information on this point. So when you're requesting medical documentation because of an underlying condition for the purposes of a disability accommodation, be clear that you are documenting why you are asking for the medical documentation, and also be aware that the EEOC has also stated that employers should be flexible in terms of what kind of documentation they're actually requesting for disability accommodations. This is because doctors are currently swamped and busy and have a lot going on, as we all know. So it is important that employers be more flexible. So, you know, instead of a formal doctor's note, perhaps it's an email from the doctor. You know, and be flexible in what type of accommodations you are providing. They could be temporary accommodations. And finally, understand that, you know, I flagged underlying conditions here as a potential disability because that's something that I think we're going to be seeing a lot of, but also mental health conditions that could potentially be disabilities. This pandemic has, I think, maybe perpetuated a lot of people's mental health conditions. If you have depression, it can be really hard to be isolated by yourself for long periods of time at home. So employers should be aware that those issues may be coming up as well. And moving briefly to the Families First Coronavirus Response Act. Before I get into this, I would like to say this is a brief overview of this. There is actually an entire portion of a webinar that I did a few weeks ago that is available on Reinhardt's Coronavirus Resource Center. It was for the Veterans Chamber of Commerce, but it gives a detailed overview into the Families First Coronavirus Response Act. So if employers would like to check that out as well, that'll give you more information on you know, intermittent leave and other more nuanced issues that come up under this law. But briefly, I'll go over the types of leave, who can take leave. I already addressed requests for documentation, so I've already flagged that issue, and then I'll briefly talk about its interaction with the Paycheck Protection Program, which I know a lot of employers are familiar with, for better or worse. So there are two types of leave under the FFCRA. We have emergency paid sick leave, and then we have expanded FMLA. So the emergency paid sick leave provides a maximum of 80 hours of leave to full-time employees that is paid at either the employee's regular rate or 2/3 their regular rate, depending on what type of leave the employee takes. There are 6 reasons an employee can take leave under the FFCRA. I encourage employers to go to Reinhardt's Coronavirus Resource Center or the Department of Labor's website and familiarize yourself with these types of leaves, or watch the webinar I mentioned. You know, they're on their face, they may not seem as expansive as they potentially are, or they're actually more limited than they seem. So just familiarize yourself with that. You may have employees requesting paid leave under that, under the FFCRA. Second is the expanded FMLA. It's a maximum of 12 weeks with the first 2 weeks unpaid, and then the remaining 10 weeks paid at 2/3 an employee's regular rate. There is a cap on how much an employee can actually get paid under both types of leave. These types of leave apply to employers with fewer than 500 employees in the US. So that's important that it's in the United States. So if you have an affiliated or foreign employer, or you're a subsidiary of a foreign employer, you would not count the employees outside the United States when determining whether or not you actually have to administer the leave under the FFCRA. Important to note that the expanded FMLA, an employee has to be employed by you for at least 30 days to qualify. However, under the emergency paid sick leave, there is no length of employment qualification requirement. One issue I do want to flag is you should determine whether or not you are a joint employer or integrated employer for purposes of counting how many employees you have. Again, there's more information on Reinhardt's Coronavirus Resource Center, on the Department of Labor, and on that webinar I mentioned about this analysis. It is fact specific, and it is something that I would actually encourage you reaching out to your attorney to get more information about, because it can be somewhat complicated. So one brief note on the FFCRA's interaction with the PPP, or the Paycheck Protection Program. Just be aware that there can be conflicting goals, and this may not be so much of an issue anymore as more and more loans are distributed. But in terms of employee count, some employers may say, well, you know, I have more than 500 employees by this count, and that way I can avoid administering FFCRA leave, whereas you want fewer than 500 employees to actually qualify for a loan under the Paycheck Protection Program. So, you know, just be aware that there are conflicting goals there, and there are different ways to count employees under both laws. So just because you have 500 employees or more or less for purposes of the FFCRA doesn't mean the employee count is going to be the same for the Paycheck Protection Program. Finally, I just wanted to flag a brief note about the Paycheck Protection Program as we all return to work. You cannot use Paycheck Protection Program funds to pay for FFCRA leave, because you are able to claim a tax credit for the leave that you pay for FFCRA. So this tax credit goes towards the employer portion of the Social Security tax. There is an application on the IRS's website that employers can look at. But again, you cannot use PPP funds to pay for FFCRA leave. If you do use PPP funds to pay for FFCRA, the funds will not be forgivable. To put this bluntly or simply, you can't double dip between both programs. Also, a reminder, today is the deadline to pay back, or the repayment deadline under the PPP. If you have questions about the PPP, we strongly encourage you to reach out to business law attorneys or any attorney in Reinhardt. We can direct you to the right person to discuss this. As employers probably know, there's been so much different and conflicting guidance issued about the PPP over the last few months, and the program has changed drastically since Congress first implemented it. So if you have any questions, we strongly encourage you to reach out to your attorney. So I will now turn it over to Rebecca Green, who's going to give a great overview about EV issues.
Thanks, Shannon. So I wanted to start with a slide here on issues affecting retirement plans. These aren't necessarily issues that arise because you might be reopening your offices, but these are good. This is a good time to take a look at some of these changes that have occurred in the last couple of months. We're going to start with some COVID-specific law changes. As happened in the recession in 2009, Congress included with the stimulus bill, also known as the CARES Act, some retirement plan relief. One of those items is the waiver of 2020 required minimum distributions for defined contribution plans. We don't have any guidance yet from the IRS on whether that's a mandatory provision that plan sponsors must waive required minimum distributions, or if it will be optional. It was optional back in 2009. Hopefully we'll have some guidance on that soon. But this provision will either allow or mandate an employer to waive the 2020 any 2020 required minimum distribution paid under the plan. You might know these as 70.5 distributions, although that different law changed that age requirement can now be up to 72. So that's one change. The other two changes are clearly optional. Employers are able to offer a coronavirus-related distribution, sometimes called a CRD, and expand the availability of loans to certain individuals who qualify. The law defines those eligible for these distributions and expanded loans as a participant who has either been diagnosed with COVID, has a spouse or dependent diagnosed with COVID, or has experienced an adverse financial consequence as a result of a quarantine, furlough, layoff, reduction in hours, or inability to work due to loss of childcare. So it's a very limited group of people that are allowed to take these distributions. But if an employer decides to add them, it would allow an employee to either take a CRD, which is a distribution of up to $100,000, or expanded loans. Those are the expanded availability of the loan is for a loan of up to $100,000, or if lesser, the entire account balance. As you may know, current loan requirements are much lower than that. And so both of these provisions are only available for a short period of time. Coronavirus-related distributions would only be available through the end of 2020. These additional loans would only be available through the end of September, roughly the end of September. So those are things that an employer could implement. You've probably, if you sponsor a retirement plan, you've probably already been contacted by your record keeper about whether you want to implement those changes. You can still implement them if you perhaps decided when the law was initially passed to wait. You could contact your record keeper and implement them now. It is entirely up to you. Plan amendments are going to be required for those changes, but not this year. So that's not an immediate action item for you. But you should, if you're, as you're working with your record keeper, you need to be mindful that the plan will need to be amended. Moving on to some plan design questions. These are optional changes that employers often consider or need to look at anytime you have a significant economic downturn. The first one is suspending employer contributions into your 401k plan, say a matching contribution. And the key for this is review your plan document. Can you do it? How do I do it? Review your plan document and then consult an advisor. There is almost always a participant notice required. There will be a plan amendment required. There will be rules about what matching contributions or for what period they can be suspended. So you need to work with your advisors and look at your plan document. There are some consequences to doing this. You typically are going to be able to do it in some form, but there are consequences. For example, if you sponsor a safe harbor 401k plan, suspending the employer match or non-qualified or non-elective contribution, will result in the loss of safe harbor status. That's not detrimental to your plan's qualified status, but you do need to understand it and understand how to plan for that. Also, another issue that has come up, as Rob was talking about, not all employers have union employees, but if you do, you need to confirm with the collective bargaining agreement and your labor advisors whether you can suspend any employer contributions for the union population or if you're prohibited. It would usually, retirement benefits are mandatory subject to bargaining, and usually the collective bargaining agreement addresses them. So that's a very important point you need to do in advance. Another issue that employers run into is distributions. And sometimes because of the unusual nature of this particular situation with the pandemic and how it's impacted employers differently, you may want to work with your record keeper to make sure that people who took employees who took distributions or former employees who took distributions were actually eligible to do so under the terms of your plan document. I'm thinking a very common error to be made is an employer sends an eligibility file to their plan record keeper, uses a code for how the employee was furloughed perhaps. When the record keeper gets that code, they don't recognize it immediately, so maybe they've miscoded in the system, and that employee who is actually not terminated was allowed to go in and request a distribution, and they did so. Those are things that you want to double check, maybe do a sample audit to make sure that distributions that have occurred over the last few months and will occur as you bring your employees back are correct. Another big concern that I wanted to point out is layoffs. If an employer lays off a substantial portion of its workforce, that can trigger something called a partial termination of the plan, and that triggers full vesting for affected employees. Whether you've had a partial termination is a conclusion that you need to, it's a facts and circumstances test, and it's a conclusion you need to draw with your advisors. But I will say the IRS rule of thumb is 20%. If you've had a 20% reduction of your plan participation as a result of either a single event or rolling layoffs as a result of this pandemic, you need to talk to somebody about a partial termination and how that impacts your plan. And finally, a couple of issues that have come up. Shannon was just talking about the FFCRA, both the emergency paid leave and the expanded FMLA. I just want to piggyback a little bit and talk about 2 points for your retirement plan that you need to at least be cognizant of and look into. Employees who take paid FFCRA leave or the expanded FMLA will be entitled to hours of service credit for those periods. Those are paid leave service credit. I should say will generally be required depending on what type of service accrediting rules your plan has. So that's something you need to double check as those employees take those leaves. And then another issue is to review the plan's definition of compensation to determine whether those paid leave amounts are included in the plan's definition of compensation for purposes of employee deferrals and employer contributions. Again, it's a check your plan document. It's easier to check those things on the front end, then find out later you made a mistake. Mistakes are fixable, but it's always a little bit more difficult than checking it on the front end. So that's something you may want to consult your advisors on soon. And that's all I have for the retirement plans. Moving on to other benefit plans, we're specifically going to focus on your health and welfare arrangements. One of the big issues right now as you're bringing employees back for your health and welfare plans are who's eligible and how do you get people re-enrolled. So the first question is, how have you handled benefit plan eligibility during the shutdown and as you look to bring your workforce back up to full speed? It's important, the key point I want to make is your plan document and your insurance policy, if you're an insured plan, usually describe the eligibility rules for the plan. You have a list of eligibility rules somewhere. So employees who are maybe furloughed or have their hours reduced might be impacted under the terms of the policy or the plan. Maybe if you have a 30-hour threshold for eligibility for your health plan, but as a result of this return to work, your particular return to work scenario, you reduce those hours maybe to 25. Well, now you have an employee who is less than that 30-hour threshold. Are you going to let them stay on the health plan? Are you not? If so, those documents need to be updated and you need to talk to your insurer about, if you're an insured plan, about making sure that those eligibility conditions align with what you're doing in your workforce. You have a lot of flexibility, but you also have to check your documents and make sure they align. The next thing I want to talk about is how to get people re-enrolled and get their payroll deductions restarted if they've been laid off and returned to work. And the number one rule here is read your plan documents, especially your cafeteria plan. You might also know it as a 125 plan. The IRS just published a couple weeks ago new guidance providing employers the option to provide more flexibility than the law currently allows to allow employees who return to work after a COVID-19 related layoff to make changes to their prior elections, elect new coverage, drop their coverage in more circumstances than would otherwise currently be allowed. These changes are optional, and if you allow the changes, it's important to note notice is going to be required to participants, and then a plan amendment will be required. So you have that option, but you have to provide notice and amend your plan. So again, talk to your provider who handles your payroll deductions to make sure that those steps are taken correctly. There's also a relief for employers who, for the FSA, for example, if you allow a grace period, normally allow employees to use up their 2019 elections through March 15th. Well, obviously that was right as things were getting started. Doctors were shutting down. The IRS has allowed an extension of that grace period. Again, it's optional, and you need to provide notice and amend your plan if you're going to want to allow employees extra time to use up those dollars that they would have had to use up by March 15th. Another point I wanted to bring up is that voluntary separation programs. I'm sorry, notices. First, we'll talk about notices. There are usually requirements when you change the content of your plans to provide notices to participants, either a summary of material modifications. In some cases, you have to update the summary of benefits and coverage. You need to consult with an advisor over what changes you might have made as a result of the COVID-19 pandemic to your health plan and figure out what notices you need to provide to participants. And finally, I'm going to briefly touch on this. I'm running out of time, and I want to talk about one more thing. So this last bullet on this slide here, many employers implement or choose to implement some type of voluntary separation or severance program in conjunction with an economic downturn to provide a softer landing for participants that you're either downsizing or you've discovered you're letting go because you're going to eliminate their position. It is extremely important to work with legal counsel, not just a consultant, but legal counsel in conjunction with these programs. Just like you may have done them in 2009, they can be very effective, but this is not something that you can just take those documents off the shelf and dust them off and update the date and use them again. It's something that has to be, it should be reviewed by legal counsel to make sure that you're accomplishing your goal and protecting yourself as the employer by getting certain releases signed. So that's all I'll say about that. And then moving on to this last slide with our last minute here, I just wanted to point out both for employers and employees, there are deadlines. There are typically deadlines to complete certain activities. For employees, it's deadlines to enroll, elect COBRA, make claims, file a claim appeal. For employers, it includes filing your annual report, your Form 5500, sending certain disclosures to employees. The Department of Labor has extended these types of deadlines or softened these deadlines in light of the pandemic. For participants, that means that beginning March 1st and ending 60 days after the national emergency has ended, so we don't yet know what that end date will be, that time period does not count towards special enrollment deadlines, COBRA election deadlines, and filing certain claims or appeals. Filing certain claims or appeals. For employers, that means employers who have to deliver these notices during that same time period, as long as the employer acts in good faith and delivers the guidance or delivers the disclosure as soon as reasonably practicable, that would satisfy the employer's delivery guidelines. In addition, there is also some relief for the use of electronic means such as email or posting notices to a website. That constitutes a good faith effort to distribute the notice, which is good news for plan sponsors. And finally, this relief applies for employers, it applies to summary plan descriptions, summaries of material modifications, summary annual reports, the SBC, your annual funding notice, participant benefit statements, and claim and appeal denial notices. So these are all good. This is all good news for an employer who has a lot on their plate right now. And that's all I've got for benefit considerations. And I'm going to throw it back to Chris to wrap us up.
All right. Thanks, Rebecca. And thanks to all of you who could participate today. This program will be on our coronavirus resource section of our website, along with a lot of other materials that we've put out over the last couple of months that relate to coronavirus issues. So feel free to look there for anything that you may need. We want to be a resource for everyone to help during these times. And if you had any questions, we'll try to get responses to those as promptly as we can. And again, we appreciate your participation. Thanks.